Take a look at those legal stories making headlines. Quentin Brogdon, legal analyst, joining us now. Quentin, good morning.
Good morning, Bloomdaddy. How are you today?
Good. Before we get into the three topics, I wanted to ask you about this Chauvin attorney filing a motion for a new trial. So they are contending that there should have been a change of venue, that the jurors should have been sequestered, and now you've got a juror, Brandon Mitchell. Picture is making the rounds on social media. He attended a rally back in D.C., commemorating the 57th anniversary of Dr. King's I Have a Dream speech, which that's fine. But in the photo, he's wearing a T-shirt that reads, "Get your knee off our necks" in BLM. So you've got some legal analysts out there saying that because of this T-shirt, at minimum, he'll have to be questioned, and depending on his answers, a mistrial could be declared. I mean, this is a guy who is making a decision when it comes to Chauvin, the man who had his knee on George Floyd's neck. This is a guy who is determining the rest of his life, who has a shirt on from earlier saying, "Get your knee off our necks." Do you think this will play in any way, shape, or form?
It could, Bloomdaddy. It depends. But the jurors were given a questionnaire before the trial that had a question on it about whether they had attended any protests over police brutality. And this juror supposedly wrote that he had not. Turns out, it appears at least, that's not correct. And if you're on trial, as Chauvin was in this case for this kind of charge, it certainly creates an appearance of somebody who may have made up their mind about the issue. Having said that, it's tough. It's very tough to reopen deliberations and to get a verdict overturned. It's not easy. But this certainly will give Chauvin some hope of that.
Now, he was asked about this, as you just mentioned, and he said that he was wearing the T-shirt because of the circumstances of 2020, not because he was attending what he believed to be a protest focused solely on Floyd. He's saying, "I was there to commemorate Dr. King, and I wore the T-shirt because of the circumstances, not because I had made my mind up." How's that, again, going to play?
Well, it's a case-by-case analysis. And it's not easy, as I say, to get something overturned.
Right.
So it's difficult to handicap it. But certainly if you're Chauvin's lawyers, it gives you a foothold in the side of the cliff, no question.
If you're Chauvin's lawyers, too, how did you miss this when it came to questioning jurors? I mean, did somebody miss something here?
That's an excellent question.
Yeah.
Part of the due diligence now when you're picking a jury is, finding you don't hack into their accounts. You don't pretend to be Facebook friends. Clearly you can't do those things. Things that are just out there on the internet that you can get to without going through any paywalls or pretending to be somebody you're not. Certainly that is fair game today, and some would argue it's required.
All right, let's take a look at some of these legal stories making headlines. Let's start at Bowling Green State University, where you've got the issue of Stone Fultz, 20-year-old student found unconscious after an off-campus fraternity party that was on March 4th. 8 people indicted on charges ranging from involuntary manslaughter to hazing. How do you see this playing out?
Well, this appears to be yet another fraternity encouraging hazing or at least looking the other way, and there have been too many reports like this over the years. I think these frat brothers face some serious charges, particularly the big brother. He's been charged with quite a few serious things. First-degree manslaughter, which is a felony with a maximum of 11 years in prison, and third-degree manslaughter charge, and a hazing charge. Most states have now criminalized hazing because of deaths and serious injuries over the years. So we have universities looking the other way. So the other fraternity brothers have been charged with lesser charges, but they're all in serious jeopardy. The frat's been kicked off the university campus, and the university says it's not going to be recognized on campus again.
How can, if somebody was just there, but they didn't do anything, how likely are they to get convicted? I mean, in a lot of these hazing cases, Quentin, you have the case of, well, we just thought he passed out. We put him to bed. Somebody didn't call 911 when maybe they should have. But, you're talking about 19, 20, 21-year-old adults.
That's right. There were 8 charged, and one of them faced the least charges, misdemeanor hazing and failing to comply with underage alcohol laws. Mm-hmm. So I predict that frat brother of the 8 was the least culpable and maybe has a defense. I was simply there. Yes, we were drinking, but I didn't realize the seriousness of it. And that's part of the reason these hazing laws were enacted by many states, is to try and at least eliminate that defense. If you're participating in hazing, you are per se committing at least some degree of a crime,
Right.
based on the laws in most states now.
Talking to legal analyst Quentin Brogdon right now. We got a disbarred attorney sentenced for stealing $1 million that was awarded to an NYPD officer who contracted cancer at Ground Zero. First of all, if you're stealing $1 million from somebody who was awarded that money because they got cancer from Ground Zero, I think that reserves you a seat in hell between David Hasselhoff and Andy Dick. I mean, that is about as low as you can go, Quentin. But again, how do you see this one playing out?
Well, I think it's already pointed out. This is a sad, sad story. One of your most sacred trusts as an attorney is to safeguard your client's funds. This attorney forgot that. Some would use less charitable words for what he did. And now he's paying a steep price. He's been disbarred, and he's been sentenced to almost, just over 4 years in prison. Most would argue perhaps that kind of crime should have merited even stiffer sentence.
Yeah, absolutely.
Apparently, he settled this case and kept telling his client, who's a retired NYPD cop, that the money hadn't been released by the fund. He told the client that for 3 years, and finally the client figured out,
oh my,
maybe my lawyer has my money.
Unbelievable. Real quick, the Boy Scouts just reached a $650 million deal with their insurer to cover sex abuse claims.
That will go into a fund that's been set up for these sex abuse claims for over 10 years now. Sex abuse claims against the Boy Scouts have dominated national headlines. About 10 years ago, one of the victims got a verdict of just under $20 million. And in that case, the so-called perversion files were released showing that the Scouts had for years kept track of banned volunteers, over 1,000 of them, and they didn't consistently report them to the police, to the parents, and to the public. So it's not going away anytime soon, this story, but this money frees up a big chunk of insurance money, mainly from insurance policies issued in the 1970s.
All right. Quentin, appreciate the time, man. Thank you.
Stay safe, Bloomdaddy. Take care.